is a community education production brought to you by the Bar Association of Montgomery County and the Montgomery County, Maryland Bar Foundation. The program is designed to provide you with general information regarding your rights and obligations under the law. It is not intended as specific legal advice. You should discuss the facts and circumstances of any particular matter with your own attorney and obtain advice specific to your case. The participants are local attorneys who have volunteered their time to bring you this program. We hope you find it informative and beneficial.
Welcome to Law School for the Public. My name is Mark Gilday, and I'm a partner in the law firm of Bregman, Burbridge, Schwartz & Gilday, located in Bethesda, Maryland. People often get confused between wills and trusts because they know they both have something to do with giving your assets to other people. But these two documents, although sometimes related, are very different and serve very different purposes. In today's show, we are going to discuss wills and trusts, the differences between them, and finally, do I need one? To answer these and other questions, we are fortunate to have with us two guests who are highly qualified to discuss wills and trusts. First, we have Kathy Mack. Kathy is with the law offices of Catherine R. Mack, located in Bethesda, Maryland. Kathy received her undergraduate degree from the University of Wisconsin, and before she went to law school, she spent several years as a police officer with the Washington, D.C. Metropolitan Police Department. After Kathy left the police department, she attended Catholic University's Columbus School of Law, where she graduated #1 in her class. Kathy's law practice focuses on will preparation, trust creation and implementation, estate and other tax planning, business succession planning, powers of attorney and medical directives, and estate administration. Kathy is a member of the Estates and Trusts Law sections of the Maryland Bar and Bar Association of Montgomery County. Next, we have Patrick Howley. Patrick is a shareholder in the Trust and Estates Department at the law firm of Shulman Rogers, located in Potomac, Maryland. Patrick received his undergraduate degree from the Boston College and his law degree from Catholic University's Columbus School of Law. Patrick's law practice focuses on estate planning for individuals and families, as well as representation of fiduciaries in the administration of estates and trusts. Patrick has lectured extensively on estate planning issues for financial institutions, civil organizations, and community organizations. Kathy, Pat, thank you for joining us tonight. And if I could begin on this subject with you, Pat, and if I were a prospective client thinking about that I need a will, what would happen when I come to visit you in your office?
Sure. Well, the first thing I'd want to do is I'd want to learn about you. I'd want to learn about your family. I'd want to learn about your assets. I'd ask you some questions to try to learn what it is that you have and who you might intend to give that to.
And then what happens next? Kathy?
Well, what happens next is basically what you tell us you want to do. For some people, they want a lot more privacy, and so maybe they would rather have a simple will with a trust. Other people, a husband and wife with small children, it's a very simple instrument whereby we use a testamentary instrument called a will, a last will and testament for each parent. Each person has his or her own will, and that will dictates a number of things on how things are distributed after your death.
Well, before we go into discussing a will, let me ask you, I come to you, I've got various types of personal property, I've got various types of real property, and I want to know what's going to happen to this property when I die. Where does it go, and what vehicle dictates where that property goes?
Well, the thing that dictates where your property goes really is the title to the property. So a lot of people think that their will kind of controls the disposition of everything that they have when they pass away, but that's really not true. The title to your property controls first and foremost. So for instance, a lot of people own property jointly with another person. Most married couples, they'll own their house as what's called joint with the right of survivorship, or for married couples, tenancy by the entirety. What that means is that when one owner dies, the other one automatically owns the property.
All right, well, let me stop you there. So If I own a house with my wife and that property is titled tenants by the entirety, and that's typically how husband and wife hold real
Correct.
property, and I were to pass first, where does that house go?
Automatically, your wife is the owner of that property.
And is that regardless of what I may put in my will?
It is.
Okay. So that's one manner in which property can pass.
And you don't even need to change the deed. It
Okay.
happens, as Pat says, as a matter of law. Even if you don't get around to changing the actual title, your wife owns that property.
All right. And then how else does property pass upon someone's death?
Another way that property commonly passes is by beneficiary designation. So if you have a life insurance policy or if you have a retirement account, a 401k, typically that's going to pass by a beneficiary designation that hopefully you've completed for either that policy or for that account. That will determine by contract where that property goes. So if your will says my 401k goes to my brother, but your beneficiary designation says it goes to my children, it's going to go to your children.
All right. When you talk about beneficiary designation, when is that filled out? And where is that filled out? Is that filled out in your office? Is that filled out with human relations at my job? Where do I do that?
Both.
Okay.
If it's a life insurance policy, you can usually do it with the help of your life insurance agent. If it's through your job, your 401k, then you probably will do it with your benefits administrator at your job. If it's an IRA, that IRA is held by some financial institution, and they have a beneficiary designation form that they will give to you. You prepare it. It's signed by you, frequently witnessed, sometimes notarized, and it's done in that way, but it has to be returned to your benefits administrator, to your financial advisor if it's an IRA, and it's just important to complete it and to return it.
So if I have an IRA or a life insurance policy at work, I can go into HR or with whomever the life insurance broker is, and I can fill out the beneficiary is my little brother. And that's what's going to govern when I die?
Assuming you have only one little brother.
Right.
Yes.
And I specifically identify that brother.
It's good to, usually these forms require the full name, the social security number, and date of birth,
So
even.
regardless of what the rest of my family may think, or regardless of what's in the will, the beneficiary designation, again, is going to control.
Correct.
right.
It does.
Okay. So we've talked about property that's held jointly, and however that's held jointly, that's going to control where that property goes upon death, correct?
Correct?
And then we have beneficiary designation, and that's going to control where that goes upon death, right?
Correct.
All right,
Correct.
what else is there? What other vehicles are there to transfer property upon death?
Well, as you said earlier, you can always use a trust,
Okay.
a revocable trust, title assets into a trust, or have your will say whatever's in my probate estate, turn it over to my trust, transfer it to my trust, and then your trust can be a vehicle that will dictate how assets are distributed.
All right, well, you just used some words that I don't know that we fully understand. You talked about probate, and so define for us, tell us just very generally, what is probate?
Sure. Probate is a process where your will, it's Latin for to prove. It's a process where your will is proven to be a valid will, and then a person who you appoint, your executor or personal representative, basically has to prove that they carry out the terms of your will. But backing up a little bit, we want to talk about what property actually passes through a will or passes through this probate process. So we talked about the joint property, we talked about the property subject to beneficiary designations. That leaves the property that might just be titled in your individual name. So if you're a single person, you're a widow, you're a widower, and you have property, a house, a bank account, a brokerage account that's just titled in your individual name. Upon your death, that property is what's known as probate property. It has to pass through this process. If you have a will, that will is going to direct how that process goes. If you don't have a will, the state's already written one for you. The law controls where your property goes. It's actually written in a way that I would say Kathy and I probably would agree. We've rarely had a client come into us and say, I want it written just like the state writes it for me. It's almost never that way. So, but if you don't have a will, it's going to be provided for.
So some people say you have a will even if you think you don't have a will because Maryland has created a will for you.
And when you say Maryland has created a will for you, there is a law,
Yes.
and that law is on the books in Maryland, And if you die without a will, that law dictates the transfer and distribution of your probate assets. Is that correct?
That's correct.
Correct.
Okay. And it could go whatever the lines are, wherever the transfers are by that statute.
And as Pat said earlier, rarely does a client want assets. When the clients come in, what they tell us, it isn't what would happen under the laws, what are called the laws of intestacy.
So we'll talk about wills first. We've talked about joint ownership. We understand where that goes. We've talked about beneficiary designation forms. We understand where that goes. And now we want to talk about wills. What does a will do? Pat, what does a will do?
A will, it provides for the disposition of your property, again, the property that's passing through that probate process, your individually titled property. It's frequently going to name who your family is, and it can contain bequests of property. It can contain instructions for payment of debts, payment of expenses of your estate, payment of taxes, and then it can provide for the naming of a guardian, for instance, if you have a minor child. It can establish different types of trusts. Frequently, if you have minor children, you might want to set up a trust in your will that provides that the kids won't get money before they reach an age that you decide. All of this can be accomplished in your will. You can give property away by percentages, you can give it by specific amounts, you can give specific items, you could give somebody a watch, you could give them a car, you could give them an interest in a business. All of these things can be accomplished in your will.
Right. And they need to be specifically detailed, delineated, identified, correct?
Correct.
So there's no confusion or ambiguity about what it is you're doing in that will, correct?
Correct, and if there is any ambiguity or confusion, the Register of Wills, which is the department of the court in Maryland that governs the probate process, requires that any ambiguity be clarified before distribution can occur.
Who clarifies that ambiguity?
Usually the drafter of the will, if
Okay.
that person can be found.
All right.
And sometimes it's really difficult. Usually, most times it's very clear, but they do require usually a petition to the court to determine distribution if there's confusion.
And it's worthwhile to avoid that, obviously, by not having that ambiguity. So saying something like my cousin Joe Smith, and you might have 3 cousins named Joseph Smith, one first cousin, one second cousin, you're going to have a problem. You might have to go to court to figure that out. So being clear is very important.
Patrick, you talked about a number of things that could be in the will and that you could use a will for. So let's talk about a few of those. First of all, presumably you need to identify with specificity the property that is going to be part of that will. Is that correct? Be it real property or personal property?
Well, but you don't necessarily identify it in the will.
Mm-hmm.
You identify it with your attorney who drafts the will.
Well, that's what I mean. When I
Yeah.
come to you as the client, you and I need to agree and be specific as to what is going to be part of this will.
And we want to be careful to make it clear that you don't need to list every item that you own. So sometimes people, frequently when they do a will, frankly, that they can buy online, they'll fill out a list of every asset that they own on that particular day. Well, as we know, over the course of your life, those assets change. Generally, you can specifically say, I want to give away this piece of property to this person, but then there's something called your residuary estate. That's basically the remainder of all your property. You don't know what that's going to be, but all of those things generally are passed at the end of your will, saying whatever's left goes to these beneficiaries.
And who does this? Upon my death, who takes care of all these things? Who gets the car to my brother? Who gets the jewelry to my daughter? Who takes care of all that?
Well, the person who's really responsible for seeing that it happens, who's not maybe the person who actually does it, is the personal representative or the executor. Frequently where we have a family with children who are surviving, and the children get along, and one of the children is the personal representative, but other children help out. But legally, it's the personal representative who's responsible.
Is it my job as the client meeting with you to identify who that personal representative would be?
Yes, and it's also important to get the personal representative's consent to serve in that capacity. People don't like to be surprised after a family member or a friend dies to find out they have this very important job.
Is that a requirement that they obtain the consent of
No,
the-
it's not required, it's advisable.
All right, so it's advisable, and this personal representative is also sometimes referred to generically as the executor.
Yes.
That's the way most people think of it.
Okay.
And frequently what we would say is a good idea is name several people. You can name one person and name 2 or 3 people to be backups, because hopefully you don't have to do this, prepare a will very often, but things are going to change. If a person passes away, a lot of couples will name their spouse as the personal representative, but they're going to want to name one or both, or if they have several children, maybe in a certain order as the next one's in line.
And if I am named personal representative in somebody's will, that person dies, I learn that I'm the personal representative, do I have to do it?
You do
No.
not.
Okay, what happens if I decide not to do it?
You resign.
That's as simple as that?
Well, there's a particular form that you sign, and we file it with the court.
Okay, but they can't make me
They
be a
can't make you
personal.
do it.
No one can make, this is not involuntary servitude.
Okay. Now, Pat, you mentioned in a will you can address issues for young children under the age of 18. You mentioned that I believe that you would want to identify a guardian for your children.
Correct. For a guardian of the person who's going to determine where your child lives, where your child goes to school, make healthcare decisions for your child until the child turns 18.
And then what about if there's life insurance or some monies left after I pass and the child is under age 18? What happens to that?
Well, if you don't provide any other instructions about that, a guardian of the property would be appointed to hold that property as well. We'd recommend avoiding that with your will by providing that a trust would be created under your will. And that trust can really kind of say whatever you want, but it's there to take care of your kids for under whatever terms you select, typically provide for education, housing, other expenses, and you can pick an age that it continues to. Some people say that their kids are kids until they're 60. They can do that. They could keep it in trust for the person's entire life. A lot of times they might keep it to a younger age, 30, 25, something
Okay,
like
and
that.
that's if I'm the one making the will with that trust in it for my minor children, I can put whatever age limit or restriction on it that I want?
Absolutely.
And can the person in charge of the child, the guardian, be the same person as the person in charge of the money?
Absolutely.
Okay.
But it doesn't have to be.
Doesn't have to be.
But I think it's important that people know that if they do have minor children, and I'm sure Pat agrees with me on this, and they have life insurance at work, or they have a retirement account, you don't want to go the route of guardian of the property for the child, because it's very costly and very restrictive. And so it's really advisable for people with children, in particular minor children, to do a simple will, just on the outside chance something would happen to both the spouses, and this poor child is, the money available for the child is somewhat tied up.
And one thing you can do is you can direct in your beneficiary designation. Now this typically might take some help to accomplish, but you can direct in your life insurance beneficiary designation that if your children are the beneficiaries, the money can actually be paid to a trust under your will. So sometimes people have no assets passing under their will, and it sets up a trust for their kids, but they also have life insurance that's going to go directly to their children and their minors. That can be a disaster. So they might have done all this planning, but they've got $1 million of life insurance, and it passes to their 2 12-year-old and 10-year-old children. In the beneficiary designation, you can actually direct that money gets paid to a trust created under your will.
Okay. Which means you need to coordinate when someone comes to see one of you, you need to coordinate with them what their life insurance policies say, what their IRAs say,
That's right.
what their retirement
Correct.
accounts say.
Or how to prepare the beneficiary designation form.
So
Exactly.
the client has come to you, you've explained to them the various ways the property can be transferred, joint title, beneficiary designation, under a will, under a trust. And with respect to a will, we've now gone through what's going to be in it, where I want everything to go. Finally, mechanically, what happens? How does that will become valid? Do I have to sign it? Do I need witnesses? What needs to be done here in Maryland to make that a valid will?
You have to sign it, and there have to be witnesses, and there's sort of some special language that should be in the signature block part of the will.
Okay, so we'll call those magic legal words.
Magic legal words.
And those are absolutely required under Maryland law. Is that correct?
Yes.
So if I am at home, I can sketch out a will by hand, but if I don't have the magic words and the number of witnesses at the end,
Which is only 2.
which is only 2, okay, that's not going to be valid in all likelihood.
In all likelihood.
Okay.
You have to be very careful with the execution of a will. It's something that we see mistakes made very frequently, so somebody very carefully plans out their estate, and then they make a mistake with the execution, and that will is not a will.
Okay.
The other thing I think that's important to note here is the importance of the safekeeping of that will after you've signed it. Because under law in Maryland, it's the original of the will that gets filed. And there's a presumption that you destroyed the original will if it's only a copy that's found. Now there's a way to get around that, but it's really, really important for people to be very careful with that original will and keep it in a very safe place.
Well, we were discussing what happens mechanically. We've decided what's going to go in it, and you've told us how we're going to sign it. We're going to sign it in your office with the magic language, the proper number of witnesses, and then we have an original will. What do you all recommend to your clients that they do with that original will, or what do you offer to them with regard to that original will?
Well, it's my practice to recommend that clients leave their will with us. We have a vault that we keep wills in. Our firm has been around for 45 years, and we're not aware of having ever lost a will. We have had many clients come to us, or more frequently the children of people who passed away, and they're in a panic because they can't find the will. And we've found wills, we've located wills in some very strange places over the years. So rather than have a frantic search where you're tearing apart a house, looking under hampers, for instance, to see if it's taped to the bottom, having it somewhere where it's safe. You can also file it with the Register of Wills in the county where you live. So at the Register of Wills in Montgomery County, you can actually pay a small fee and put your will on file.
And that's what I do typically.
Okay.
I have my clients file their wills with the Register of Wills for $5.
All right, so you earlier talked about probate. Is there a way to avoid probate?
There is. There are several ways, the joint ownership, things like that. There's one way that's very common, very popular lately, and that's called a revocable trust or a living trust, or sometimes a revocable living trust. But using that type of trust really is a way to effectively probate your estate while you're still alive. You're kind of doing the work that your executor would do to retitle things after you pass away, but you're doing that up front.
And what are some benefits to a revocable trust? We avoid probate, correct?
Correct, if it's done properly. I would say the biggest benefit, other than avoiding probate, is privacy. A probate proceeding, when your will is filed after you pass away, your assets are reported, there are certain disclosures made, and those are all public. Anybody can walk into the office there at the Register of Wills and ask to see your will and ask to see what assets you had. With a revocable trust, it's a private proceeding. Only beneficiaries are able to see that.
And are there certain circumstances where it is a good idea to have this revocable trust? For example, if you have a home in Maryland and you have a beach house in Delaware, or you have a home in somewhere other than Maryland.
It's very smart to have a trust.
So you don't have to go through this probate process in the various jurisdictions.
Right.
Correct.
Okay.
And another important consideration is if you have a business. Frequently people have businesses that may be sold after they pass away. There may be some issues related to the value of the business. And it can be a good idea not to have to disclose the value or whatever somebody thinks is the value of that property or that business in a public court record, but instead to keep that private so it doesn't have to go through the probate process. Having that business interest owned by a trust can accomplish that.
And if it went through your will, as you said, that would all be part of the probate process and be public.
Correct.
Correct.
Okay. And what are some basic elements? We talked about basic elements of will, some basic elements of a trust. You would have to specifically identify that which is going into the trust, correct?
You do, but the first thing you want to do is establish the trust. And a trust is very similar to a will. It's just a legal document. I liken it often to a corporation or a company. You're establishing this entity, this trust. You're referring to yourself in the third person. You name yourself as the trustee. You're also the beneficiary. You're also the grantor of the trust. And you transfer from yourself to yourself as trustee this various property. The rules that govern how it works, those are in the trust document. While you're alive, you can revoke it. You can change it any time you want. Upon your death, it effectively converts to a will and accomplishes the same thing as your will.
And what, in your experience, is the most common mistake that people make when they set up a trust, Kathy?
Well, the biggest mistake, and sometimes it's the lawyer's fault, is they fail to transfer their assets into the trust. I have a form that I give my clients for investment accounts, for bank accounts, that they can just fill in some blanks and hand it to their investment advisor or their banker. And I also facilitate the transfer of the real property into the trust for the client, particularly with elderly clients. It's important to hold their hand.
So in other words, once I've established this trust with the help of the lawyer, and I say I want to put my home, let's talk about my home specifically. I need to make sure that that home gets deeded from my name personally into the Mark Gilday Revocable Trust.
Correct.
And if that's not done, the trust with respect to the house.
It's not the end of the world, but you're still going to have the probate process.
With
And the whole point of doing the trust was, one of the big points of doing it was to avoid that.
Yeah, frequently I find, and Pat may have the same thing, when the house is titled in the name of the husband and the wife, in order to do the revocable trust, they have to split the title. Half goes in the husband's trust, half goes in the wife's trust. They don't want to bother with it until the first spouse dies, and then they transfer into a trust.
So if there's one lesson I think we take away from this, it's that a trust or will, one size does not fit all, correct?
Correct.
Never.
Everybody has unique
Absolutely.
circumstances. And two, it does behoove the person to seek the advice of a professional who does this type of work.
All the time.
That's correct.
Okay, because mistakes are easy to make, and what you think you may be accomplishing, you may not accomplish at all. Is that
That's right.
fair?
That is fair.
Absolutely.
Those mistakes can be permanent, so.
Okay. Well, thank you very much. There is much more that we would like to know about wills and trust, but we have run out of time in today's program. I would like to thank our guests, Kathy Mack and Patrick Howley, for being with us today. Everyone from your host and the guests to those behind the cameras volunteers their time to produce this program. Please let us know what you think of the show, as well as what topics you would like to see on future programs by emailing us at lawschoolforthepublic@gmail.com. You can find this show and past shows online by searching Law School for the Public Montgomery and following the link. This program airs every Wednesday at 7:30 p.m. on Channel 21. Please join us for future shows in our Law School for the Public series. On behalf of the Bar Foundation of Montgomery County, I am your host, Mark Gilday. Thank you for watching.